So thank you, Tim, and thank you, ASU and the Coalition on SB 1070 for having me here. It's a pleasure to be here in Phoenix. The bill has received a lot of media attention about what it means for people of Arizona and why it is or might not be good public policy, but less attention has been paid to the legal validity of the bill. And as many of you know, there are many perfectly valid laws that are poor policy. And what is maybe a drier topic is when a law is itself illegal. So I want to give you guys some color about where we stand and why we think, even though we recognize that there is a problem with illegal immigration in Arizona, that the way to tackle that problem is not through a law like SB 1070, which we firmly believe is unconstitutional. So before we even get into the specific provisions of SB 1070, one of the overarching constitutional defects of this Arizona law is that it violates something called the Supremacy Clause of the US Constitution. This clause establishes that the Constitution, federal statutes, and treaties are the supreme law of the United States, and that it therefore allows the United States to legislate in an area to preempt any state legislation. That is to say that the state may not legislate concurrently in that area. So take the example of foreign relations. Would it make sense to you for states to be permitted to make their own treaties with various countries, or to impose their own tariffs on imports and exports of goods? The federal government has decided that the answer is no. Rightfully so. It will essentially create chaos. And it has preempted states from legislating in the area of foreign policy. Similarly, the federal government has an interest in uniformity in the execution of our immigration laws. Who is permitted to be here, how one gets here, how one is deported, how long one can stay. It has expressed its intention to preempt state legislation in this area through the Immigration and Nationality Act. States have no authority to pass immigration laws. So the debate sometimes with a lot of state legislation is, well, is this law really an immigration law? And that is something that's up for debate and something that the courts will have to deal with. Our perspective is that SB 1070 is squarely an immigration law. It relates specifically to the enforcement of federal immigration law and sanctions violators of that law. So one of the main refrains of supporters of SB 1070 is that there's nothing wrong when the law simply enforces federal law. That might be a good soundbite, but that holds no water under our Constitution. Suppose, going back to the foreign policy example, the foreign relations example that I just used, that the federal government has imposed an embargo on, say, North Korea. And Arizona decides, you know what, if that's the case, we're going to impose a special tax on any business that ends up having goods, arriving in North Korea. Can Arizona do that? Even though Arizona thinks that it's helping further US foreign policy, doing so, in effect, interferes with the ability of the federal government to determine how to implement the embargo. The US may be trying to relax the embargo as an incentive for North Korea to stop its nuclear program, which is something, in fact, it's trying to do. And what Arizona might be doing, or what other states might be doing, would undermine what the United States is trying to achieve. Likewise, the federal government exclusively decides when, how, and to what extent its immigration law should be enforced. Individual states have no authority to interfere, regardless of whether they think that they're helping the federal government or angry that the federal government is not doing its job. One specific provision of the bill is illustrative of this problem. And I'm sure many of you are very familiar with the many provisions of this bill already. But one of them is the requirement that non-citizens, what we call aliens under the INA, carry registration documents with them at all times. It's correct, this is part of federal law. What is less well known is that this provision of the INA has not been updated in 30 years. That the list of documents listed in that INA provision are no longer current. And that many documents exist to show that you have permission to be in the United States that is not in that statute. And the federal government, for those very reasons, has decided not to enforce those provisions actively. It's on the books, but the federal government has chosen not to make it a priority in its immigration enforcement scheme. For Arizona to now elevate the priority of this immigration enforcement provision in the way it has under SB 1070 interferes with federal government's ability and authority to exclusively enforce immigration laws. And that is why, as an example, SB 1070 violates the Supremacy Clause. So what I just outlined is actually one of the stronger arguments under the law as to the constitutionality of SB 1070. It's not really one of the most dynamic arguments. In the public debate, it's very hard for us to sort of go into all of this to explain why the law is unconstitutional. It's not really a satisfying answer. And much more of the media attention has been focused on the specific provisions. And even there, we have significant constitutional issues. So turning to the specific provisions of SB 1070, I'm not going to go through all of them. I want to just give you all a highlight of some of the issues that we find with this law. One that has generated probably the most heated discussion is the whole reasonable suspicion provision. It's the one that says that a state or a local, I guess, law enforcement officer must determine the immigration status of anyone they reasonably suspect is unlawfully present. And everyone's been saying how this is going to lead to racial profiling. So before I even talk about why this provision is unconstitutional, I want to just take a step back and talk about the link between this provision and the outcry that this is going to lead to rampant racial profiling. Racial profiling refers to the use by law enforcement personnel of an individual's race or ethnicity as a factor in articulating reasonable suspicion to stop, question, or arrest an individual, unless the race or ethnicity is part of an identifying description of a specific suspect. Racial profiling sends a dehumanizing message that that a certain person is judged simply by the color of the skin. Imagine a police department that's trying to respond to an increase in white supremacist activity in Phoenix. And it decides to stop all white residents to inquire if they've been involved just because they're white. Your race, your ethnicity, something that you cannot change, what we call under the law an immutable characteristic, should never be considered a proxy for criminal behavior. Those who argue that racial profiling is acceptable because most undocumented immigrants in Arizona are Mexican forget that most Mexicans in Arizona are not undocumented. So why does 1070 lead to racial profiling? It's because of a very fundamental problem that it asks law enforcement to discern someone's status. And it removes law enforcement from focusing on someone's conduct, which has traditionally been the role of the police. Status is unobservable. Conduct is. Reasonable suspicion is an established legal standard. Yes, that's true, but only when it's tied to whether someone is engaging in criminal conduct or about to engage in criminal conduct. And these are things that police can observe and can see and can say, you're about to do something, I'm going to stop you. How is he supposed to do that with someone's status? An officer is inevitably going to take into account race or ethnicity. Imagine if a driver was stopped and could not produce an Arizona driver's license. So in fact, this is really beyond race at this point. He can't produce an Arizona driver's license, which kind of suggests maybe this person could be undocumented. But he tells the officer, officer, I'm really sorry, I left it at home. I left my driver's license at home. Do you think there will be a difference in how a police officer will respond to that explanation depending on whether the driver was white or Mexican? Do you think it's possible for the police to be race neutral in these situations? In fact, the American Psychological Association, just a few days ago, came out strongly to talk about the virtual impossibility of law enforcement officers in these situations to be neutral, and that they will always carry implicit bias, regardless of how much training you put them through. This provision invites the police to base their reasonable suspicion on people who they think look or sound foreign, perhaps people who dress a certain way or speak English with an accent. Just like race, these factors cannot be generalized as proxies for criminal behavior or for one's immigration status. Let's not forget there are a myriad of ways that foreigners have permission to be in the United States. And it's particularly an issue in Arizona, where over a third of immigrants arrived in 2000 or later. So they're not established citizens who've been in the United States for a long time. These people could have just come in recently on a family visa, an employment visa. They could be a tourist. They could be seeking asylum. There are many ways someone who looks or sounds foreign has legal permission to be here. So why does racial profiling violate the Constitution? Sort of bring us back to kind of the legal argument that we have in our lawsuit. And it's that racial profiling violates the Equal Protection Clause of the 14th Amendment, which provides that all people must be treated equally before the law. When an immutable characteristic like your skin color, complexion, ethnic appearance is used as a basis for being stopped or questioned by the police, you are not being treated equally before the law. The effect of this reasonable suspicion provision also has other consequences that lead to that has constitutional implications. It will have what we anticipate to be a chilling effect on speech and your First Amendment right to free expression, association, and your right to petition the government for redress of your grievances. As you all know, because the statute places people who may look or sound foreign under reasonable suspicion, individuals are likely to be hesitant to speak in a foreign language because such speech in itself might warrant reasonable suspicion. It will interfere with people's ability to want to associate with other minorities. You know, do I want to get into a car with 5 other Latinos or 5 other Asians who can't speak English? Even though we all have legal status, am I going to want to do that? I'm going to rethink. I'm going to think twice before I do that under SB 1070. Okay. And finally, I want to address the idea that this law also has a fundamental problem with a lot of vagueness around a lot of its provisions. And to stop this idea of vagueness is very important because under our Constitution, laws must be passed in a way for people to know how they can conform their behavior to avoid being punished by that law. I want to leave you with this thought, since clearly my time is out and I've made it through about 1/3 of what I had prepared to say.
Oh my gosh.
And that is, you know, would you know how to conform your behavior when you're out on the streets to avoid being caught up by SB 1070? Would you know how to do that? There are, I want to close, and I want to just reiterate what I said at the very beginning, is that us lawyers, we're from DC, I know, we get a bad name, but we are not here to say there's no problems with illegal immigration here. But when we go about dealing with our public policy problems in a way that violates our Constitution, we open a slippery slope to a parade of horrors. I want to encourage you to pick up a lot of our fact sheets that we've prepared that goes into some of these issues, but also talks more specifically about the impact of the bill on Asian Pacific Americans, the national consequences that SB 1070 has been causing, and some backgrounders on the status of the undocumented population, specifically within the AAPI communities. I do work for an Asian Pacific American civil rights organization, so I do want to say that that's some of the issues we want to address, and you'll be able to find more information about that in some of our materials. Look forward to your questions and answers. I look forward to your questions. Thanks very much.